Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. On April 18th, 2025, the state of Idaho scored a victory in receiving a favorable ruling denying the defense's motion in limine regarding make and model of suspect vehicle. This had to do with the defense's argument that expert testimony concluding that the car, the vehicle that is apparently picked up in video that was provided to law enforcement after a canvass of the area around 1122 King Road was the same vehicle, suspect vehicle 1, would this type of testimony by an expert, the way that it's put here, is usurp the role of the jury, and that's located at the bottom of page 3 of this order. I want to go over a bit of the language of this order before we go into the jury's role versus the judge's role. This order begins on page 1 by saying, in the early morning hours of November 13th, 2022, surveillance videos from various locations near the crime scene picked up footage of what law enforcement believed to be the same vehicle as suspect vehicle 1, the white sedan that was seen arriving at and then departing. It says then depart from the area of 1122 King Road at the time of the crimes. From one such video, law enforcement determined the vehicle was a 2011 through a 2016 Hyundai Elantra. Defendant seeks an order precluding the state from referring to the vehicles depicted on the various surveillance videos as the same vehicle, i.e. suspect vehicle 1, and from asserting that suspect vehicle 1 is a 2014 to 2016 Hyundai Elantra. He argues that these are speculative conclusions that invade the province of the jury. The state responds that it intends to elicit expert testimony establishing the vehicles are the same, and such testimony will be neither speculative nor otherwise improper. The court then goes into the standard under Section 2, the admissibility of expert testimony, that it is discretionary. That means that the court has latitude to determine whether expert testimony should be admitted in to the jury trial or not, citing to legal authority State versus Almaraz. This is a 2013 Idaho Supreme Court case, which gives the test. So while the court does have discretion, it's not boundless. It must be reasonable, in other words. The next section goes into the facts as the court understands them. Then the analysis section, applying the facts as the court understands it to the law. We see here the court's understanding and belief that an opinion is speculative when it, quote, theorizes about a matter as to which evidence is not sufficient for certain knowledge, end quote, and suggests only possibilities. And this is State versus Calise Bautista. This is a Court of Appeals ruling from Idaho. And then applying this legal standard to the facts, the court says here law enforcement's opinion that the vehicle captured on the Ridge Road camera at 4:01 a.m. is suspect vehicle 1. Captured at 4:04 a.m. on the 1112 King Road footage is not based on unsupported theories or possibilities. Rather, the opinion is based on the investigator's training and experience and educated inferences drawn from their review of surveillance footage from 6 locations within a mile of the crime scene during the hour preceding the crime. From this evidence, the investigators were able to map what they believed was the suspect vehicle's route of travel preceding the crime, as well as identify its make and model. Then, this is where, if you look into the next paragraph, opinion testimony, and this is by the experts, according to the court, would not usurp the jury's role as fact finder. The jury is tasked, they're charged with determining whether the defendant committed the alleged crimes. The state asserts the perpetrator drove suspect vehicle 1, and based on the totality of evidence, if we go to the next page where this continues, that it was defendant's Hyundai Elantra. The investigators' observations and inferences about the route of travel of the vehicle, its make and model, whether the Ridge Road footage from 4:01 a.m. and the King Road footage from 4:04 a.m. depict the same vehicle, and whether the depictions were all the perpetrator vehicles are relevant to this determination. And then going to the jury's role here, once again, the jury is free to weigh this evidence and the investigator's testimony against that offered by defendant and decide for itself, that's referring to the jury, ladies and gentlemen, what the surveillance videos depict and whether it supports its ultimate conclusion bearing on the defendant's guilt. So going to what the jury versus the court's role is, because the proposed jury instructions that both sides submitted to the court have been filed under seal. It's likely that we will not know until trial what the jury instructions in its final form are. I want to cite to you for ICJI 201. This is a standard jury instruction that you can find on the Idaho Supreme Court's website if you follow this link, and it is entitled Role of Judge and Jury. This one instruction says, "You have now heard all of the evidence in the case. My duty is to instruct you as to the law. You must follow all the rules as I explain them to you. You may not follow some and ignore others, even if you disagree or don't understand the reasons for some of the rules. You are bound to follow them. If anyone states a rule of law different from any that I tell you, it is my instruction that you must follow." So this appears to be a jury instruction that would be given at the conclusion of the case before the jury retires to the jury room to start deliberating for the first time on the evidence that they were privy to that was presented to them, and to come to the ultimate conclusion that this jury will come to as to whether or not Mr. Kohberger is guilty or not guilty of the 5 first-degree felonies that he was charged with by indictment that he is standing trial on. And at all times, it is important to remember that Mr. Kohberger is considered innocent under the eyes of the law until or such time that that jury returns a verdict of guilty or he pleads guilty. The second jury instruction that I wanted to call your attention to is ICJI 202, determining facts from the evidence and disregarding non-evidence. And this has to do with the jury's role as the finder of fact. It says here, as members of the jury, it is your duty to decide what the facts are and to apply those facts to the law that I have given you. You are to decide the facts from all the evidence presented in the case. The evidence you are to consider consists of, number 1, sworn testimony of witnesses. This will be the lay witnesses and the expert witnesses, ladies and gentlemen, that are testifying at the future trial. Number 2, exhibits which have been admitted into evidence. And number 3, any facts to which the parties have stipulated, and that means that they have agreed to. Certain things you have heard or seen are not evidence, including 1, arguments and statements by lawyers. The lawyers are not witnesses. What they say in their opening statements, closing statements, and at other times is included to help you interpret the evidence, but it is not evidence. If the facts as you remember them differ from the way the lawyers have stated them, follow your memory. Testimony that has been excluded or stricken, or which you have been instructed to disregard. And number 3, anything you may have seen or heard when the court was not in session. This will conclude this episode of the Indie Zone. Thank you for joining us here today.